In determining eligibility for Social Security disability benefits, your age is a very important factor. In general, it is easier to qualify for Social Security disability insurance benefits if you are older than 50. Let's look at an example. Here are Bob and Jim. Bob is 25. Jim is 52. But in all other areas of their lives that are pertinent to a Social Security disability case, Bob and Jim are exactly the same. Both graduated from high school and have worked their whole lives in the Walmart warehouse as a laborer. This job is classified as unskilled, requires the ability to lift and carry 20 to 50 pounds occasionally, and 10 to 25 pounds frequently. Both hurt their backs, had a lumbar fusion, and were not released to go back to their Walmart laborer jobs by their doctors because they could not stand and walk for most of the workday and could lift no more than 10 pounds. Bob and Jim were in essence released to do so-called sedentary work. So, what will Bob and Jim do if they file claims for Social Security disability? Their past work and the ability to work found by their doctors is exactly the same. You might think they would both get the same result, but you would be wrong. To understand the situation best, I need to explain a bit about Social Security disability law. I promise it will be easy. When an administrative judge makes a disability decision on a case, a key finding she must make is this: what is the disability applicant's residual functional capacity? RFC is simply put, what can the claimant do despite their impairments? The ALJ will often express RFC in terms of the 5 broad job classes found in a key government publication, the Dictionary of Occupational Titles. Those categories are very heavy, heavy, medium, light, and sedentary. Once the judge has determined what the claimant's residual functional capacity is, she will apply these same broad categories of job types, sedentary, light, medium, and heavy, to the claimant's past work. In Jim and Bob's case, she is likely to find their past relevant work was at the medium exertional level. Now that she has classified both Jim and Bob's past work and their remaining workability in terms of these broad work categories, she must compare them to determine, could Jim and Bob go back to any prior work? The comparison of RFC and the demands of prior work that these job categories, from the very heavy, the least restrictive, the sedentary, the most restrictive. In other words, if you do very heavy work, you can do a sit-down job. But if you can only do sedentary, you cannot do very heavy work. To make it easy to understand how this works, think of these broad work categories as Russian dolls. To find a disability claimant able to return to prior work, the residual functional capacity Russian doll must fit in the past work Russian doll. So, the next important question the ALJ asks is this: could Bob and Jim do other work? This is the critical question in the disability case. If the answer is yes, there is other work the claimant could do. Then, the disability will be denied. To approve the disability claim, the ALJ must find no other work existing in sufficient numbers could be performed by the claimant. In determining if some can do other work is available, the Social Security Administration uses a tool called the grids. The grids are a set of tables, one table for each residual functional capacity class: sedentary, light, medium, heavy, very heavy. The grid table directs a decision of disabled or not disabled based upon age, education, and work experience. Let's see how Bob and Jim do under the grids. Let me again emphasize, the disability cases for Bob and Jim are identical. They both graduated from high school, they both had the same work background, and for both, but what a difference age makes. For 25-year-old Bob, the grids direct a finding of not disabled. And 52-year-old Jim, the grids direct a finding of disabled. So thanks to age, Bob loses and Jim wins. This might make sense to you. Of course, Jim is older. But remember that Jim and Bob had exactly the same residual functional capacity. That is, physically, they can do exactly the same thing. This is not the only example of how age could mean the difference between winning and losing a disability case. In addition to age 50, ages 55, and 60 are also very significant.